30-minute dinner break. Are they coming down?
They were lined up, Judge.
That you know doesn't close
Oh, I'm
till 8,
sorry.
so I'll just go and break for dinner.
Yeah.
And I'll just close until 8.
Okay. All right.
They're coming down tomorrow.
All rise.
All right, please be seated. All right, Joe Norma.
Ladies and gentlemen, we have finally reached the point in this trial where all of the evidence has been submitted to you. We talked what seems like a very long time ago in jury selection about that there were two components to every trial and two things that you needed to do your job as a juror. The first is the evidence. What comes in through the witness stand, through the witness's testimony, the actual physical evidence that's introduced. I think we have over 50 exhibits that you have seen, and you can go back through if you choose to in the deliberation room. Which I don't mean to scare you by saying we're only halfway there, because it won't take as long. But until the judge gives you the law, you can't do your job of deliberating. And after closing arguments, after the attorneys both have a chance to speak with you, Judge Watkins will provide you with that law. And that law will be the jury instruction, which we talked about this in jury selection too, that this is your manual. And while a lot of times people, it might be, yes, I've heard all of this. Yes, we've been talking about this all week. This is the law. You swore an oath that you would apply this law to the evidence. And I am going to ask you to do that. Now, of course, again, it seems like everything in this trial has been somewhat lengthy. This is not a short document. And to ensure that you hear the entire law, Judge Watkins will read it to you at the end of closing arguments. And I just want to go through a few of the things, because far back into the jury instructions, it actually tells you one of the first things that you need to know is that you must begin with the indicted offense. The law requires you to. In this case, there are 5 counts of aggravated rape and 2 counts of aggravated sexual battery. You are required as jurors to determine guilt or innocence on that indicted offense. So you would all 12 have to vote not guilty to move on to any lesser included offenses. Which I tell you this because, again, if you are the type to not use the manual, when the judge reads out the jury instruction, the law requires him to read out lesser included offenses. And you will see that the verdict form has many options, but you are required to consider the indicted offense. And I want to go through some of the law that you will be considering. There are 2 statutes, aggravated rape and aggravated sexual battery. We have multiple counts, but there's only 2 statutes that you'll be considering. We talked about this in jury selection, that the first element that the state has to prove is that the defendant had unlawful sexual penetration of the alleged victim. And the law is going to provide you with every definition and everything that you need to know. It is going to give you definitions of every term. The second element is that the defendant was aided or abetted by one or more persons. The third, that the defendant knew or had reason to know that the alleged victim was mentally incapacitated or physically helpless. And then the last element is the mental state. Again, I want to go back to the first element, unlawful sexual penetration. The law gives you the definition of what penetration is, and it may be more than the common understanding. Sexual penetration includes sexual intercourse. It also includes fellatio, anal intercourse, and it includes any other intrusion, however slight, of any part of a person's body or of an object into the genital or anal openings of the alleged victims, the defendant's, or any other person's body, and the emission of semen is not required. That is the legal definition of penetration that you will be using when you are determining each count of aggravated rape. And the law goes further. Again, it provides definitions for everything. It defines fellatio for you. And again, the law might not be the same as common understanding. This is a sex act accomplished with a male sex organ in the mouth or lips of another. But the law goes further and says intrusion into the alleged victim's mouth is not required. It is not required under the law. It also defines the third element and tells you what an aider and abettor is. It is one who advises, counsels, procures, or encourages another to commit a crime. It also defines mentally incapacitated. That a person, you're going to be read these by the judge. I'm not going to go through and read every one to you, but you're going to get these definitions, and it's the legal definition that you must use. It will define for you what physically helpless means. And I want to stress that the fourth element, while it might seem innocuous, it is extremely important. And it is extremely important especially for the first 4 counts of aggravated rape. Because the law says that the defendant has to act intentionally, knowingly, or recklessly. And because the law says recklessly is a mental state that suffices, that means that intoxication, it is not a defense. It is not a defense for Mr. Batey for the first 4 counts of aggravated rape. If you are the principal offender, if you are the person that is penetrating the victim, you cannot assert intoxication as a defense under the law. The law says that cannot happen. Now we have other counts in the indictment. The 5th count actually is an aggravated rape where Mr. Banks is the person that is penetrating. It is not Mr. Batey. And we'll talk in a minute about criminal responsibility, but in that circumstance, you can consider intoxication. You can consider it for the 2 counts of aggravated sexual battery. Aggravated sexual battery, we have our first element. The second and third are exactly the same as aggravated rape. It's if you have 1 or more, and it is if you knew or had reason to know that the victim was mentally incapacitated or physically helpless. And the last element, again, while it might seem innocuous, that's what makes it different, because the defendant has to act intentionally. And then we also have the first element that differentiates it from an aggravated rape. And it's that the defendant had unlawful sexual contact with the alleged victim in which the defendant intentionally touched the alleged victim's intimate parts or the clothing covering the immediate area of the victim's intimate parts. And again, the law goes further and it defines these terms for you. It tells you what sexual contact is. That it is the intentional touching of the alleged victims, and it goes on to include defendants or any other person's intimate parts. And it includes that it has to be done for the purpose of sexual arousal or gratification. That is something that you have to determine. It defines intimate parts. And again, this might not be the common understanding. Intimate parts includes primary genital area. It includes the groin. It includes the inner thigh. It includes the buttock. And that is important because count 7 of the indictment, Cory Batey is charged with aggravated sexual battery for pulling down his underpants and sitting on the face of the unconscious victim and putting his buttocks and groin area in the face of the unconscious victim. That is what the indictment is for in this case, and you have seen a photograph of just that. And in that photograph, you actually see that Cory Batey is able to squat and balance on one arm and actually raise his middle finger and flip off someone that's across the room taking the picture. You have two people, the person taking the picture, and then you actually see Mr. McKenzie on the other side of the room taking another picture, and he is flipping him off while balancing in a squatted position on one hand. I submit to you that that is proof beyond a reasonable doubt that not only is Cory Batey guilty of that aggravated sexual battery, but that there is no intoxication defense based on all of those factors. Criminal responsibility. Criminal responsibility for the conduct of another. Again, just to make it clear and easy, the first 4 counts, Mr. Batey is the principal. Intoxication is not a defense. He is also the principal in the 7th count. So you're only going to be considering criminal responsibility as it relates to counts 5 and 6. This is the definition of criminal responsibility. And I'm not asking any of you to actually try to read that because I know that the print is very small. It is a lengthy definition. I'm not going to go through all of it with you now. But you will be provided the full definition in the jury instruction. The section that's highlighted is the basic concept of criminal responsibility. You are criminally responsible for the conduct or for an offense committed by the conduct of another if acting with the intent. So you have to have the intent to promote or assist in the commission of the offense, or, and again, commas, ors, and ands are very important when you are reading the law, or to benefit in the proceeds or the results of the offense. So if you are attempting to assist and you are intending on benefiting in the result because you and your 3 friends are all in a room together and you are all engaging in behavior where you are insulting an unconscious female. 3 of you don't even know her. And you are taking pictures. And somebody's giving you a phone. Mr. Batey's giving Mr. McKenzie a phone, and Mr. McKenzie is taking pictures for him. And you hear people laughing. You hear Mr. Vandenburg telling Mr. Banks what to do. And if you are all doing it together to assist each other and to benefit in whatever it is that you think you are getting out of what you are doing, you are criminally responsible and you are guilty for not only your conduct, but the conduct of the other people that are with you. The law says that encouragement of the principal is sufficient. Encouragement. That can be laughing. That can be taking pictures. Encouragement of the principal offender is sufficient. Ladies and gentlemen, I want to talk to you about what happened on June 23rd of 2013. And I know that the evidence in this case is not something that anybody wants to look at. It's hard to look at. But it is photographic evidence. of the crimes committed in this case. And I am not going to show you every image. You have seen them. You saw 30 images, 30 different thumbnails, and there were 3 video files. Now, the thumbnails included the video files, so we have 30 total images. The evidence that you have has 49 seconds of video out of 32 minutes. The victim in this case was in that dorm room with Mr. Batey, Mr. Banks, Mr. McKenzie, and Mr. Vandenburg for 32 minutes. And the only one that didn't leave the room during that entire time is Mr. Batey. He was in there the entire time. The others left, came in and out, not for long. Nobody left for more than 2 or 3 minutes total, but 32 minutes, and you saw 49 seconds. What's even more is that the 49 seconds that you saw all occurred within the first 3 minutes of them being in that room. That's what they were able to do in 49 seconds. The first video file is at 2:40:10. In those first 3 minutes, there are 3 acts of aggravated rape that are committed on the victim. The first one that is in photographs and videos. Again, just because we don't have a photograph of it, just because we don't have a video of it, doesn't mean that it didn't happen. We just happen to have more than that this time. We have more than enough. We have 110% because we have a video of it. And again, I do not want to show you these images to upset you and make you look at them again, but it is the evidence, and it's the evidence of what happened to the victim in this case. You have 2 thumbnail images of the first count of aggravated rape, which is Mr. Batey. He digitally penetrated the victim's vagina. The first count. There are 2 thumbnail images, as well as there's a video file. Exhibit 30D, thumbnail image. And again, I'm putting these up briefly. You have another thumbnail image of the digital vaginal penetration, Exhibit 28G. You also have an Exhibit 36D. And again, I'm not going to play this video file for you again because I know you've already seen it. In Exhibit 36D, there are 6 video files on that disc. The first one is of the video out in the hallway where she is unconscious. Mr. Vandenburg and Mr. Banks are taking pictures and laughing. The second video is in the dorm room, and it's the one that occurs at 2:40:10. And you saw that video. Each video is on there in full speed and in 50% speed, and you can watch them if you need to. But that 7-second video, that second video file, it's IMG_1400. You saw Mr. Batey, and you saw him penetrating her vagina. An actual video file in addition to the 2 pictures that you have. And then at 2:40 and 50 seconds, again, this is 3 minutes. Within 3 minutes, count 5, aggravated rape. Mr. Banks has inserted a bottle into the victim's anus. You saw this video file. You actually see him doing that. And I am, again, not going to play the entire thing again. I know that you have already seen this. It is image_1401. And in that 42-second video file, within 42 seconds, there are 2 counts of aggravated rape. You have Mr. Banks with a water bottle squeezing it. You can listen to the audio in that file, and you hear Mr. Vandenburg saying, squeeze it, squeeze it. You hear everyone laughing. And in that same video file, 37 seconds into it, at 2:41:27, this is a still image if you hit pause. This image. This is the exact same image, just turned right side up. You see the unconscious victim. And this is 3 minutes into the room. Mr. Batey has his pants off, he has his shoes off, he is on the ground. And he has his hands in front of his penis as if he is putting it in her vagina. Now, Mr. McKenzie couldn't tell you that he actually saw the penis go in the vagina, but you have this video. You can see what's happening. You also heard other evidence of Mr. McKenzie telling you that he asked him the next day, and he said he got it in. But again, this is within 3 minutes. Mr. Batey still was in there for 29 more minutes. You see brief glimpses of what happened to the victim in that room. But this is what Mr. Batey was doing at 29 minutes left. And again, the legal definition of aggravated rape is that it is any intrusion, no matter how slight. You will not find anything in this jury instruction that says his penis has to be erect and there is some amount of depth of penetration. It says any penetration, no matter how slight. And I submit to you that that is proof beyond a reasonable doubt that he is guilty of count 4. That he is guilty of count 4 of penetrating her vagina. And again, that doesn't mean that Mr. McKenzie's testimony that he attempted it and then he actually was able to penetrate her, that doesn't mean that both of those things are not true, because we just don't have a video of what happened after this. When you look at the evidence that you have, at the exhibits, and you were shown them in a sequence from each person's phone, but the thumbnails don't have any XIF data, so you don't have the date and time stamp. But if you look at them all together, you can see the stages of the attack. You can see that this didn't all happen right away. This thumbnail image is 28H. This is a 10-second video clip. This video is not recovered. It wasn't sent to anyone. And again, we have a video within 2 minutes where Mr. Batey is already doing more and penetrating her. And this video clip, he is just inside the room. He doesn't have his pants off yet. He doesn't have his gold black tennis shoes off yet. And you see the victim on the ground. You see where she is by the closet in that video clip, by that left closet with her head near that green towel on the hook. But what you really see is that you can tell that she still has her shirt on, and it's not undone. You can tell that she still has her skirt on, and you can see her purple-gray underwear. And then as you go through the pictures, you later see that she doesn't. Actually, the first thing that happens is you see Mr. Batey with his pants on. Then you see his shoes are off, his pants are off, but then you see that her skirt, it gets pulled up here. And you have series of photographs with the skirt pulled up, the panties still on. And then you see that the panties are off. And you see other stages of photographs where you see that now they have taken off her skirt. You see that her bra is off and her shirt is pulled all the way up around her neck. You see these stages of what happened to her. you also see in the surveillance video. You see that Mr. Vandenburg, at some point, he takes his clothes off. He doesn't have on his white t-shirt and jeans and black shoes. He's wearing red gym shorts and black ankle socks. You also see later in that surveillance video that Mr. Banks has his shirt off at one point. In this series of photographs, you have actual photographic evidence of count 2 of Mr. Batey penetrating the victim's anus with his fingers. And again, I am not showing you these to be graphic, but there are actual images of that penetration. Exhibit 30B and 30C are photographic images that are uncontroverted. That is clear digital anal penetration. You also have digital proof of count 3, the fellatio. Mr. McKenzie testified, he told you about Mr. Batey putting his penis in the victim's mouth. And again, he's putting it on her mouth. The fellatio does not have to be something active. It can be something that an unconscious person, it's not what they're doing, it's what Mr. Batey is doing to her. And the law says that this is aggravated rape. And the pictures and testimony and evidence that you've heard prove beyond a reasonable doubt that he is guilty of that. Again, you see the stages of what happened in that room. This is that image that we talked about earlier, where he is putting his buttocks in the victim's face. Count 7. You actually see in this image what appears to be her underwear on the chair, and you see that she doesn't have anything on the lower part of her body. But you also see that her head, it's nowhere near that green towel on the hook. She's on her back. And you also see in other pictures, she is on her stomach, she's on her back, her head is over in that far corner by the plastic tote. You actually see something red and white under her head that looks like that red and white towel from the trash. When you look at all of them, you see glimpses into the other 29 minutes. You have actual photographic evidence of count 6, aggravated sexual battery by Mr. Banks. He's taking a photograph of her primary genital area, but he is touching her. It is for the purpose of sexual gratification, I submit, because he is taking a photograph of it as he's doing it. That is Exhibit 29C. 2 minutes. 2 minutes. With the victim in this case going out with her girlfriends. She is out with her girlfriends. She sees the guy that she just met. This is supposed to be a happy, wonderful time in her life. And in an instant, it changed everything. But what was going to happen to her, however Mr. Vandenburg got her in that unconscious state that you saw her in, because you never see her conscious until hours after she arrives. None of that would have included Mr. Batey unless Mr. Batey chose. Unless he chose to do it. He is walking outside. You see him with a girl. He's going to get nachos and a quesadilla. But when he sees Mr. Vandenburg and they all go over to the car and they look in, Mr. Vandenburg, you don't see him pulling him, begging him like, no, don't go, I need your help. Mr. Batey's there. Mr. Batey doesn't actually ever help him. He doesn't help him get her to the room. He is laughing, cutting up with Mr. McKenzie. You see him up on the second floor. At one point, they have dropped the victim. Mr. Vandenburg had just dropped her on the ground. You see them carrying her by her arm, her ankles, and her wrist. It's no wonder that her shoulder is injured. Mr. Batey goes over, and it appears that he might be trying to pick her up, but it actually looks like he kicks her and drops her hands. Doesn't actually assist. But when you see him walk in that front door, and the unconscious girl is being carried in, he is excited to be walking in. He is actually skipping in the front door. And he is walking right around the corner to get in that room. Not Mr. McKenzie is talking to the girl in the yellow sweater, eating a burrito, carrying Mr. Batey's plate of nachos that he hasn't even carried up to the room. He is in that room for 32 minutes. The photographic evidence alone is proof beyond a reasonable doubt that he is guilty of every single count of the indictment. Mr. Batey did not just penetrate her every single one of those times. He did not stop at just the 5 penetrations that he is charged with. The 4 that he did, the one Mr. Banks did, and then the aggravated sexual battery. He did not stop at that. He urinated on her. Urinated on her. Rape is not about sex. It is about Mr. Batey feeling power over someone else. And he treated the victim in this case like she was a piece of trash. He urinated on her, and then they began smacking her on her bottom so hard that you can actually see handprints on each side. All the while Mr. Vandenburg saying, she won't wake up. They know she won't wake up. And Mr. Batey knew that he could do whatever he wanted to her, that he could treat her like a piece of trash. And I ask you to return a verdict that he is guilty of every single count of this indictment for what he did to the victim that day.
All right. We are going to take a 30-minute break to allow the jury to have dinner, and then we will come back and resume closing argument.
All rise. Norman, that was the best estimate I've heard in a long time. It was 30 minutes. All right, we'll be in a minute recess.
30-minute lunch break. Yeah. Did you all give the election to Jamaica?
Yeah, it's an exhibit.
Okay.
It should have gone back.
Okay.